The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Carlisle presiding.
Good morning. Welcome to the first case of the Panel C, new term here in the 5th Court, 2020-2021 term. It's good to see you all. We look forward to hearing your argument. We've read the briefing. I have a few introductory remarks. First off, we welcome any feedback you have on the electronic system here on the Zoom. Anything that you'd like to pass along that worked, that didn't work. You know, happy to hear anything the parties have to say about that. We're always trying to get better. One tip: if you start to fade in and out, I've noticed it may help to pull down the video. And if as long as we can hear you, that's all we need is the information. So if that happens, it's happened before, be cognizant of that option. That's totally fine with us. We open the term here, and I'd like to take a moment to recognize Justice David Bridges, who passed over the summer, tragically. He was to be sitting on this panel. We've moved forward, and the governor was good enough to appoint us a new justice to replace Justice Bridges, who had a huge body of work on this court. And so with that, I welcome Justice John Browning to the court, the new junior justice, where I once sat. So welcome, Justice Browning.
Justice Carlisle.
Okay, who do we have for the appellant?
Good morning, Your Honor. Matthew Sparks for the appellant.
And for the appellee?
Good morning, Your Honor. Eric Wood on behalf of the appellee.
Good morning, both of you. I'll call the case. We have number 05-20-00169-CV. This is WorldVentures Marketing versus Travel to Freedom. Mr. Sparks, when you're ready, the clock will be, I trust everybody can see it, 20 minutes for both sides and 5 for rebuttal. So when you're ready, Mr. Sparks.
Thank you. Good morning, Your Honors, and may it please the court. The key issue in this appeal is whether a plaintiff can sue for breach of contract and related causes of action relating to that contract, quoting in the plaintiff's petition word for word significant sections from that agreement, and then subsequently deny that it consented to the terms of that agreement in order to avoid enforcement of a mandatory arbitration clause in the agreement. Appellee does not deny that it quoted the so-called 2019 agreements, sections from the 2019 agreements in its petition. And that is the version of the agreement which contains the arbitration clause as well as the so-called Halliburton savings clause. In fact,
Mr. Sparks, let me ask you on that point. I noticed in the record here, we have the 2019 documents, but then I also noticed that there's other documents from other years. There seem to have been revisions, maybe almost yearly, but somewhat, maybe not quite yearly. I don't see the entirety of the contracts of the past years. Maybe we have an initial 2012 or 2011, and then we have a 2019. Do we have the full contracts of those interstitial ones? Do we have those in this record?
I don't know that the full contracts from the prior agreements are in this record. I know that the full 2019 is in the record, Your Honor. And as I was saying, the appellee does not deny that it quoted from the 2019 agreement in its petition. And in fact, as we sit here today, to date, the appellee, which is the plaintiff below, still has yet to amend its petition. And so the live pleading as of the date of the hearing on the motion to compel arbitration, as well as the live pleading as we sit here today, remains the petition which quotes upwards of 360 words directly from the 2019 agreements. I would argue that this appeal can be decided based on this judicial admission issue in and of itself without even needing to look at the affidavits. Essentially, the appellee or the plaintiff below should have been stopped from denying that it consented to the terms of the 2019 agreements when the appellee plaintiff below specifically quoted the 2019 agreements in its petition. That being said, if we do look at the evidence that was before the trial court, The trial court's finding that there was no evidence of agreement to the 2019 contract is simply unsupported by the record.
Maybe before we move to that, Mr. Sparks, I have one more question. In your motion to compel arbitration, there's an affidavit or declaration from Eric Haynes, and it references the contract. It references you have maybe 3 exhibits there. If the plaintiff's petition was a judicial admission, why would you need that affidavit?
And that's exactly my point. I don't think that we do. I don't even necessarily believe that I need to present argument as to the affidavits, because I think the issue could have been decided on the basis of the judicial admission alone. That being said, I mean, maybe it's just to, have double arguments in case the court didn't like one and would like the other. We, buttressed our argument with the declaration. And indeed, the declaration of Eric Haynes is essentially uncontroverted. The appellee or plaintiff below submitted an affidavit stating that she did not sign the 2019 agreement. Well, that's fine. We know that agreements can be reached through click-through these days. And then she also averred that she did not recall agreeing to the 2019 agreements, but that's different than saying we did not agree to the agreements. She's just saying, I don't remember agreeing to it. I don't remember agreeing to it. Whereas our client's uncontroverted testimony below was, yes, they did agree to the 2019 agreements.
Well, Mr. Sparks, let me ask you if that's your view. I mean, obviously, it was your burden to prove the existence of a contract in this case. Does that not encompass? I mean, there were various iterations of that contract, as Justice Carlisle pointed out. And you say that the 2019 contract was quoted in the pleadings. What proof do we have? Let me ask it this way: that the previous contracts did not contain that exact language, and also an illusory arbitration provision. Where is that?
So just, and I apologize, I can't quote exact pages of the record. I can follow up with a letter if you'd like, but looking at the 2012 version of the agreement, for example, which is the agreement that the appellee seems to be pushing, that language just simply isn't in that agreement. The language quoted in the appellee plaintiff below's petition is verbatim, word for word, taken out of the 2019 version of the agreement.
If the arbitration provision that governs here can be unilaterally amended, how is that not illusory under this court's holding in Weekly Homes versus Rao, or the decisions of our sister courts that are cited by opposing counsel?
It's not illusory based on the Halliburton savings clause that's contained in the provision, which provides that notice has to be provided to the other party. Additionally, that it applies, the provision applies equally to both parties to the case, and it also applies only to prospectively to future claims.
Well, counsel, speaking of those Halliburton savings clauses, is there any dispute that the Halliburton savings clauses that are present in the 2019 agreements are not present in the 2012 one?
There's no dispute. Indeed, there is not a Halliburton savings clause in the 2012 version of the agreements. That being said, the Halliburton line of cases has been applied to the employer-employee relationship, which is not the case here. I am unaware of a case which has applied those same Halliburton rules in the context of two sophisticated corporate entities, nor has appellee cited to any such case. That being said, even assuming for the sake of argument that the Halliburton, so-called Halliburton rule does indeed apply not only in the employer-employee context, but also in the context of two sophisticated corporate entities negotiating an agreement, the Halliburton savings clause is indeed contained in the 2019 version of the agreements.
Mr. Sparks, let me ask one more question to follow up. I take it by the briefing, you concede that the provision in the 2012 contract is illusory under the Halliburton tests.
If the Halliburton test indeed applies, then yes, we do concede that it is illusory.
And then why would there be a distinction in its application in an employment setting versus any other setting?
So I thought about that. I mean, really, as a matter of just public policy, it makes sense that a heightened standard would be applied in the employer-employee context.
Do you have any authority for that proposition?
I do not, Your Honor.
I mean, I can quote you long period of case law that says just the opposite, basically.
I appreciate that, Your Honor. I do not have any authority that I can cite you right at this moment. All that being said, it's our position that the trial court abused its discretion by determining that there was no evidence that Appellee agreed to the 2019 agreements. Appellee should have been stopped from denying agreement to that contract, the very contract which it sued upon and quoted in its petition. And there was clear testimony on my client's behalf, expressly stating that Appellee indeed agreed to those terms. We're asking the court to hold that a plaintiff cannot sue for breach of an agreement, quote, word for word portions of that agreement with respect to which the plaintiff contends the defendant breached, and then subsequently deny that the plaintiff agreed to that very agreement in order to avoid enforcement of an arbitration clause in the agreement.
Well,
Thank you, Your
counsel,
Honors. Yes.
counsel, I'm troubled by the equivocating language in your client CLO's affidavit that representatives, and I believe the term used, generally complete the agreement by clicking through. What was there for the trial court to actually consider as evidence of an executed agreement?
Yes, Your Honor. I'm not a fan of that generally language either, but I'm also not relying on it in connection with this appeal. What I'm looking at are other portions of the affidavit. For example, the second sentence of paragraph 3, which is page 29 of the record, states, quote, a true and correct copy of a blank form of the agreement executed by plaintiff with the attached representative terms and conditions are attached here too as Exhibit A1. And then we attach the 2019 agreement. Likewise, paragraph 5 of the same declaration states, quote, plaintiff agreed to be bound by all such covenants and obligations found in the representative agreement, representative terms and conditions, and WorldVentures policies and procedures. So those are the two sentences we're relying on. That was the evidence that was before the trial court. If there are no further questions, thank you, Your Honors.
Thank you. Mr. Wood?
Thank you. May it please the court, Justice Carlisle, Justice Mulberg, Justice Browning, Eric Wood on behalf of the appellee, Travel to Freedom, LLC. I'd like to start kind of where Mr. Sparks started, which with this alleged judicial admission argument. There's been no judicial admission in the petition that Travel to Freedom agreed to the terms of the 2019 arbitration provision. As a matter of fact, as Justice Mulberg pointed out, there's no evidence in the record whatsoever which particular contract language that came from. The petition, and nowhere in the petition at all does it say that it's citing the 2019 version, nor do the other versions that were attached and produced by WorldVentures, does it say that. So we don't know where that language came from. We don't know which agreement that came from. What we do know is that every single version of the provisions that were in front of the record, with the exception of the 2019, did not contain Halliburton savings clauses. The 2019 version did. All of the other versions that they provided did not contain Halliburton savings clauses. The 2017, 18, 16, 15, all those other versions didn't have them. So we don't know, again, which provision that language came from, but there certainly was no judicial admission. And for a judicial admission to be binding, as your honors know, it's got to be clear, deliberate, and unequivocal. There is no clear, deliberate, unequivocal statement anywhere in the petition that Travel to Freedom was relying on the 2019 version. So again, because there is no evidence that it agreed to be bound to that version, then we look back to what is the actual evidence that was before the trial court in terms of an agreement to any arbitration clause, right? The only evidence of Travel to Freedom agreeing to any arbitration clause at all was the evidence that my client put forward, which was, hey, they say we signed something, and then they attach a screenshot from 2012 as proof that we clicked through, right? So my client went back in her record and said, okay, I don't recall clicking through, but here's the version that existed in 2012. And when we look at that version, as well as every other version except for 2019, they don't contain the Halliburton savings clauses. And so because the case law is clear, and Mr. Sparks didn't even refute this, without a Halliburton savings clause, both of them, the arbitration clause is illusory and it's unenforceable. And that's the evidence for the trial court. To say that Mr. Haynes' declaration proved that my client agreed to the 2019 version, he just simply doesn't say that. He says that people generally agree to it, and then he attaches a blank form of what people generally agree to. He never comes around and says, Travel to Freedom agreed to this. When he does get around to saying it, he says, plaintiff agreed to be bound by all such covenants, and here is a true and correct copy of a screenshot proving that. So the only evidence he offers in terms of proof of my client agreeing to anything is a screenshot from 2012, which obviously could not prove my client agreed to anything in 2019. That was the evidence before the trial court. And without that evidence, the trial court just could not find in Travel to Freedom's, WorldVentures' favor in terms of the 2019 agreement, because there simply was no evidence in front of the court to hold that my client ever agreed to that particular provision, which is the only provision that wasn't illusory and unenforceable under Halliburton.
Counsel, let me ask you a question about your client's affidavit in which she says, I don't recall agreeing to this. As you know, we traditionally don't regard such equivocating or wishy-washy type of language, very strongly in terms of its value as affidavit testimony. When someone says in an affidavit supporting, say, a motion for summary judgment, to the best of my recollection, traditionally, we've not, accorded very much value to that. Can you tell us why we should treat this differently?
Absolutely, Your Honor. And I'm glad you asked this question, because I think it was a little bit unclear when Mr. Sparks cited to what her affidavit said as to what she actually said. She said unequivocally, Travel to Freedom did not sign the 2019 version of the representative agreement. Travel to Freedom did not sign the 2019 version of the policies and procedures. That is unequivocal. Travel to Freedom did not sign this. What she says is, I don't recall signing any version at all. However, even if I did, it would have had to been the version when I clicked through in 2012. So she does state unequivocally in her affidavit, and this was not challenged, Travel to Freedom did not agree to the 2019 version. So to be clear, she did say that. I want to touch on one other thing that Mr. Sparks raised with regard to the Halliburton cases only applying to the employer-employee context. That's the first I've heard of that. I certainly don't think there's any support for that proposition. As a matter of fact, we cite to a bunch of cases in our brief, some of which don't apply to an employee-employee relationship. One of the cases is Morrison. It was a Fifth Circuit case, but it was a diversity case, was almost dealing with an exact situation like this. It was an Amway distributorship, in which the distributor had a fight with Amway and was and Amway was trying to enforce an arbitration clause. So almost the exact situation we have here. We have a sophisticated business person running a distributorship in a multi-level marketing company, and that company trying to enforce the provision. And there, the Fifth Circuit found, because the provision that Amway was relying on didn't contain the Halliburton savings clauses, they were illusory and unenforceable. Again, exactly the situation we have here. It was an employee-employee context. I'm not aware of any cases saying that Halliburton only applies to that. To the contrary, the evidence shows that there are cases in which it's been held to apply, which weren't in the employee-employee context, such as Morrison. One other point, Your Honor, with regard to whether my client's breach of contract claims can move forward. I think clearly that they can. Again, that's only one of multiple claims, but I think that the breach of contract claim can move forward once you remove out or sever out the illusory and unenforceable arbitration clause. There's a long line of cases that says you can sever out an unenforceable and illusory arbitration clause, but still have a breach of contract claim under that same contract, particularly where here the very contract has a severance clause that says if one provision is removed as being unenforceable, the remaining provisions remain. So you have that provision in the actual agreement, the 2012 version, as well as the others. Then you also have cases which we cited in our brief, such as Torres, Lucchese Boot, and Morrison case, in which an illusory and unenforceable provision is removed, and the party can still move forward on a contract or contract-like claim after that provision has been severed out of the contract and doesn't affect the remaining validity of that particular claim. So in conclusion, Your Honor, the burden is obviously on the appellant. The burden was on WorldVentures as the party seeking to compel arbitration to put forth evidence of a valid arbitration agreement that wasn't illusory and unenforceable, and that my client signed that agreement. WorldVentures wholly failed to do that. The trial court entered a fact finding that is binding on this court unless appellant can show it was an abuse of discretion, stating on the record that WorldVentures did not put forth evidence that Travel to Freedom agreed to the 2019 version. And therefore, unless appellant can show that was an abuse of discretion, that finding, the appellant cannot prevail in this appeal. Appellant hasn't been able to do that and cannot do that. And therefore, unless Your Honors have any more questions, I believe that the trial court's ruling should be affirmed in its entirety. Thank you.
Thank you, Counsel.
Thank you, counsel. Mr. Sparks, rebuttal.
Thank you, Your Honors. All I'll say in rebuttal is very short and sweet. If the appellee plaintiff is suing for breach of the 2012 version of the agreement, why did they quote verbatim 360 something words of the 2019 agreement in their breach of contract action? Thank you, Your Honors.
Thank you. The case will be submitted. Appreciate your excellent briefing. Y'all have a good day.
Thank you.
Thank you, gentlemen.
Thank you.
Thank you.